Welcome, everybody, to today's webinar, Roommates and the Law in BC. My name is Paula Price. I am with the People's Law School, and I will be your host and moderator today. We have two incredible guest speakers, lawyers Anil Agarwal and Lisa Mackey from Alexander Holborn. I'll introduce them in just a few minutes. So what we'll be covering here today, the legal status of roommates, the role of a landlord, dealing with a rogue roommate, and resolving your roommate disputes. We'll spend 60 minutes together. We will be providing answers to your questions. You'll hear legal information, not advice, that is current as of today. Now, if what you're seeking is legal advice, so the law as it applies to your unique set of circumstances, we encourage you to reach out to a lawyer. You're welcome to reach out to one of our speakers. Their contact information is on the screen, and they would be happy to hear from you. We would like to acknowledge that we are grateful to work on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh nations, whose peoples continue to live on and care for these lands. And we invite everybody to reflect upon where it is that they're joining us from in the province. We would also like to thank our funders, the Department of Justice Canada, the Law Foundation of British Columbia, and the Notary Foundation, whose financial support makes it possible for us to produce these webinars. And finally, last but not least, we would like to welcome our amazing speakers. We have lawyer Lisa Mackey. She is a partner at Alexander Holborn, where she is the leader of the Residential Tenancy and Strata Property Law Practice Groups. Lisa is returning to our webinar screen for the sixth time in the last 3 years. So you may be very familiar with Lisa and know that she is absolutely outstanding. And we are thrilled to have her. She's spoken previously about evictions, rental issues, and strata. So welcome back, Lisa. It's so good to have you here.
It's great to be here, Paula. Thanks for having me.
Amazing. Thank you. And we also have Anil Agarwal. Anil is also a lawyer and partner with Alexander Holborn in Vancouver. He is part of the Residential Tenancy Strata and Insurance Law practice groups. And Anil is catching up on Lisa. He has joined us for this will be his third webinar in the last 2 years. One of which was one of the most attended webinars of, well, the most attended webinars of our series of 50 plus webinars now. And we are absolutely thrilled to have Anil join us once again. Thank you so much, Anil.
Thank you, Paula, and hello, everyone.
Amazing. Yes, I forgot to welcome our guests once again. Thank you all for being here today. We are thrilled to have you here and really excited to share today's webinar with you. So the first question is for Anil, and that is, how does the law in BC apply to roommates? For example, do tenant protections apply to roommates?
Yeah, great question, Paula. And I think a common answer you're going to hear at the outset of every question today, perhaps, will be it kind of depends, right, on the circumstances. The context is always key. And so when I think about this question, I think of two key types of situations. There could be a situation where you have two individuals, the roommates, who are both on a named tenancy agreement together with respect to a singular landlord, or alternatively, there could be a single person in that tenancy agreement named as a tenant, and they have an occupant who is not named on that tenancy agreement. And in such cases, there's a bit of a difference here. I would say generally, and generally is another key lawyerly word that we like to get away from things, but generally, if you have two individuals who are both named on a tenancy agreement with respect to a landlord, the Residential Tenancy Act is likely going to apply and provide them with various protections with respect to their landlord. So that's the key, the Residential Tenancy Act is kind of the key legislation in our province that governs landlord-tenant relationships. And so in the context of two individuals on a tenancy agreement, they're likely going to have protections afforded from that. In the situation where there's one named tenant on that agreement and an occupant, person who just comes into the unit after, that occupant doesn't really have any protections as afforded by the Tenancy Act with respect to that landlord. So that's a key thing to remember there. As between the tenants, however, the Tenancy Act doesn't apply either. And so generally speaking, a tenant or an occupant doesn't have any legislated rights against their roommate or the named tenant, but those rights would likely stem from a roommate agreement. If you think about the Big Bang Theory, Leonard and I forget Sheldon, that's I think the greatest example of roommates that could go wrong or right. And Sheldon had 1,000 clauses in his agreement. That's kind of what you'd ideally have, perhaps not so particular, but that's kind of how you, as a occupant and a named tenant, as roommates, will likely distill your rights as between each other. It'll include hopefully things like notice provisions, etc. So yeah, I think that's generally speaking, that's how the law applies with respect to roommates in our province.
Excellent. Thank you so much, Neil. So now I feel like we should have had a clip from the very famous sitcom, which I've recently learned is one of the longest running sitcoms of all time. So people are obviously very interested in roommates, what's happening between them. Um, this leads us to our next question, which is for you, Lisa. Um, so if the tenant protections don't apply, then how can you protect yourself in a roommate arrangement? And what key points, now I'm thinking of Sheldon and his list of endless points, I'm sure. What key points should your roommate agreement cover?
Yeah, and it's key to have an agreement, everybody. So one of the reminders I have for folks is that somebody can be your best friend, they can be the best colleague that you work with, but a terrible roommate to have at the end of the day. And if you're in a situation, as Anil said, where you're both not named as tenants under a tenancy agreement, which would be captured by the Residential Tenancy Act, it's super important that our living arrangement is documented by way of a roommate agreement. So a contract that specifies what are our rights and obligations with respect to our shared housing arrangement. And so it's really, really important that we put everything onto the contract that's important to us. The Tenants Resource and Advisory Center offers a wonderful template to start. So beyond today, and I can chat a little bit about what topics we might want to include in the roommate agreement, they've got an awesome template. So I encourage everybody to take a visit to that website. In terms of what you include in the roommate agreement, we don't necessarily need to pull a Sheldon. It doesn't have to be a telephone book size contract. In fact, that might scare away a few potential roommates if we're looking for someone to share a space with and pitch in on the rent. But it should cover the basics. So with any contract, the who's who in the zoo. So who are the parties to the agreement? Who's going to be living in that shared space? And then how do we use our private spaces? How do we use our shared spaces in the accommodation? So are we each entitled to our own rooms? Do we each have our own bathroom? And what have you? So what's the lay of the land in your apartment or your shared space? How is rent divvied up? So who's going to pay who? Who will be the primary contact to the owner of the property? Who's letting you use the property? Is the owner of the property one of the roommates? Are they living there? Because that will dictate how things progress under your contract as well. Household obligations, cleaning obligations, who's responsible for utilities? What are those proportionate shares like? How much notice do you have to introduce a new roommate to the arrangement? Or can you even do that without the other person's permission? What notice do you have to evict your roommate? And that would be assessed on the principles of contract law and what reasonable notice would apply there. But essentially, all of our points of connection on living together should be documented in this contract, and we should all be on the same page. Everyone should get a copy. Everyone should keep it. And then when there's a dispute or a question about our rights and obligations, we have something to go back to.
Amazing. Thanks so much, Lisa. And a follow-up question for you. If you mentioned you might want to make your arrangement before moving in with friend, colleague, uh, but if you don't come to an agreement at the very beginning, or you don't enter into an agreement at the very beginning, can you do that after you've started living together?
Sure. So you can always try, but it's going to be a little bit more difficult depending on how long you've been living together without an agreement. So they'll look in terms of if there's any dispute, the presiding judge over the dispute or the Civil Resolution Tribunal, they'll look at what were our actions with each other, what was our historic relationship with each other, not necessarily what somebody wanted to document in a contract. So I highly recommend that you have that contract in place before you actually move in together, before you start living together, because it's just going to be that much trickier to document a contract later unless you get everybody on the same page right away and everyone's super agreeable. So just better to have this in place from day one.
Excellent. Thank you so much.
I will note that on the Sheldon Cooper agreement, it does say at the very end, the most controversial clause, that all ties will be settled by Sheldon. So something to keep in mind when you're drafting your agreement, perhaps.
Make sure you read that contract carefully.
Put yourself as a tiebreaker.
Exactly. Um, and Neil, this next question is for you. How does the law apply to a homestay student?
Yeah, great question. So first thing is, well, what are homestays? And I guess homestays, as I generally understand them to be, are situations where you have often minors who come from abroad to integrate into our way of living here in British Columbia, to immerse themselves into culture, to take away something of value and help them adjust, perhaps learn English at the same time. And so that generally takes two types of forms from what I've seen. Situation one is where the person comes from abroad and they stay with the host family. They live with that host family. They are sharing perhaps kitchen facilities, bathrooms, etc. So the idea is that you immerse yourself with the family and you become a part of the family. Another situation is more formalistic, that where you come to an educational institution, and that institution perhaps has a leased premises or a premises where they house students. And so those are the two type of general situations I see where homestays are involved. If we turn our minds to the Residential Tenancy Act that I referred to before, Section 4 actually says that in such situations, the Residential Tenancy Act doesn't apply. So that's the first key takeaway, is that, underneath the Tenancy Act, those protections don't seem to manifest. And just to say verbatim, the act doesn't apply to a living accommodation owned or operated by an educational institution and provided by that institution to its students or employees. And conversely, living accommodations in which the tenant shares a bathroom or kitchen facility with the owner of that accommodation. So right off the bat, those protections are gone. So where the protections or law come from? Generally speaking, from my experience, they come from the accommodation agreement that's entered into between the parties. And so that generally is where those protections, the law that they will rely on, law of contract effectively, will generally step in at that point, and to provide those the protections that the homestay student would likely have, or that the individual hosting the student may want in those situations. But again, it comes down to context, and if it should be the case where it's not a formal homestay, it seems to be, more like a tenancy. The act does say that if it looks like a duck, walks like a duck, and talks like a duck, you may have just entered into a tenancy, not knowing it, thinking it's a homestay. So it's always just be aware of the context around what you're doing and the circumstances that underpin it. Because, generally speaking, there's not going to be an application of the Tenancy Act, but you just might walk your way into one.
Excellent. Thank you so much. And Neil, it sounds like really clarifying at the outset the nature of the relationship and the expectations of the parties. Going back to Lisa's point is really important here.
Really.
This next question is for Lisa. Does a tenant need to take their landlord's consent need their landlord's consent to take on a roommate? What if the tenancy agreement is silent about roommates?
Yeah, great question. And this happens a lot, particularly in our housing market. A lot of people will want to introduce somebody to come in as a rent helper. One of our friends, it's just more cost effective if we live together. So the first place I look is, what does my tenancy agreement say? Does it say anything about my ability to bring in a roommate? Some tenancy agreements will dictate when a long-term guest becomes an occupant of the property. And usually from what I've seen, most landlords will have a protection or a clause added to the standard form lease agreement under the Residential Tenancy Act that requires the tenant to get the landlord's prior written approval to bring in a permanent occupant or somebody to be their roommate in the space. So double check there. If the agreement is silent on that, so the landlord has not included an additional term in their lease that requires permission, then the perspective of the residential tenancy branch is that that's allowed then. You don't need the landlord's permission to introduce another person into the rental unit. Now, word of warning, it doesn't give you carte blanche the ability to introduce a ton of other people into the rental unit. So there is grounds to end a tenancy if a tenant introduces an unreasonable number of occupants into the space. So if you've got, for example, a one-bedroom unit and you've introduced 5 people into that space, the law would probably consider that to be an unreasonable number by which the landlord, regardless of whether or not they required permission to have the additional occupants, might be able to end the tenancy as a result. So as with anything, and as with Anil just chatted about with the homestay, look at your arrangement, look at your contract first and foremost, and then proceed. And just make sure that you double check those contractual terms, because you don't want that to come back to bite you later. In the event you don't ask for permission and your landlord says, well, I'm going to choose to end your tenancy because you introduced somebody without my permission.
Excellent. Thanks so much, Lisa. Follow-up question. If you're in a strata, for example, sometimes they might limit the number of occupants that are, or do they? You know this better than I
Yeah,
do. Is that a
they
possibility?
can. Yeah, so sometimes you'll see in strata corporations, and so a strata corporation is like a little mini kingdom, everybody. So it has their bylaws and rules, and it's an additional layer on top of the requirements under a tenancy agreement. And so potentially the strata might have a maximum occupancy limit per strata lot. And so that's also something to keep in mind if you're renting a property in a strata corporation. When you go to rent a property in a strata, you have to sign a document called a Form K. And what that means is it's a notice of tenant's responsibilities. It indicates you've read the bylaws, that you will abide by the bylaws as amended from time to time. So super important that we double check that if we are in a strata environment, that there's not a limit on the number of occupants as well.
Super. Thank you so much, Lisa. This next question is also for you, Lisa.
Okay.
Can a landlord raise their tenant's rent or evict them if the landlord discovers that the tenant has a roommate?
Yes. So anything is possible. So there are limits on what landlords can do. So if the landlord had a clause in their lease and it was a material term, meaning it's super important to the landlord and to the tenant at the outset of the contract, that required them to get prior written approval to introduce anybody new to the property, then potentially, yes, you can be evicted for introducing somebody else into the property without the landlord's prior written consent. So it will all depend on what the tenancy agreement says, everybody. And then in terms of an increase to rent, well, the Residential Tenancy Act does allow for the leases that are governed under that legislation, does allow the landlord to add an additional occupancy fee. It's not part of the rent, but an additional charge for introducing an occupant to the space. Now, there are limits on that. So the law changed goodness, I think it was last year, that prohibits landlords from charging additional occupancy fees for minors. So when somebody has a baby, or when somebody's child moves back into the rental property after being away, anybody under 19 years of age, you can't charge them a fee for living there. So the law is protecting those younger folks from the right to reside in the property as well. But strictly speaking, apart from minors, yes, as long as the lease spells out the amount of the charge, the increased charge, and the charge is reasonable, so it can't be overblown, then a landlord can certainly increase the cost of residing there.
Excellent. Thank you, Lisa. And if you don't mind, another follow-up question. You mentioned
Yeah.
there's a distinction between the sort of somebody who's visiting and then when somebody crosses a threshold and becomes an occupant. Is there a way of explaining when that would happen, or is that how do you know?
Yeah, great question. So usually the contract will dictate when somebody moves from being a guest to an occupant. And so the clauses that I'm familiar with, which have been passed and okayed by the Supreme Court and then the Court of Appeal, had a conclusion that an occupancy clause that said if somebody resides in a property for longer than 14 cumulative days in a calendar year, they become an occupant. Those ones were actually enforced. Now, it's again, as Anil mentioned too, it's circumstantial. confidential. So we want to make sure that each case is independently reviewed. But typically the contract will specify when someone transitions from a guest to an occupant. If it doesn't, if it's silent there, it's going to be a lot more difficult for a landlord to make an argument that they really wanted to limit occupants or that they were concerned about how long guests were staying at the property. Because as another reminder, landlords aren't allowed to unreasonably restrict someone from having guests. They can restrict occupants. So super, super tricky territory for landlords when they want to start enforcing a lease against someone that they think has transitioned from a guest to an occupant.
Fabulous. Thank you so much, Lisa. This next question is for Anil. I am one of two roommates where we're both named on the tenancy agreement. If my roommate leaves, am I on the hook for all of the rent?
Yeah, and perhaps just to clarify, when we say that you're both named on it, or in this example, they're both named on the tenancy agreement, that they're both named as tenants on the tenancy agreement, not as a tenant and an occupant. So in a situation where both individuals or both roommates are named as tenants on the tenancy agreement, the law sees them as being something called joint and severally responsible for their obligations. So they're both equally responsible to ensure that the rent is paid. And so in another example, using some TV folk, if Bert and Ernie are in this example, and I know it's really wholesome here. If Bert doesn't pay his share, then Ernie's responsible for the entirety of the amount of the rent. So you got to pick up where your perhaps partner leaves you hanging in the situation. But what happens if somebody leaves? Now, generally speaking, if there's no notice, so if Bert just says, I'm going to leave, see you later, Ernie, Ernie remains responsible for the rent ongoing, unfortunately for him. In a different situation, perhaps where Bert says, hey, I've given notice to our landlord, I'm leaving, and the other stays, it's an interesting context because now, if a tenant remains in the rental unit and continues paying the rent after the notice took effect, it might be seen as that the landlord has actually entered into a new tenancy with the remaining tenant. So there are different situations, but the remaining tenant will likely remain on the hook for the rent as long as they stay there, even if the other one leaves.
Excellent. I feel like I missed out on an opportunity to put Bert and Ernie in our slides.
I also love it that you went and Bert was the person that was misbehaving.
Bert always looks angry when I see him on
Really? Oh, I
Instagram
guess so.
memes these
That's
days.
fair.
So
I feel like Ernie's unreliable though between the two. I feel like Bert might be more responsible, but you're right, he is rather angry.
So I love this. This scenario, interesting scenario. What happens if, okay, we have here, I moved into a rental 10 years ago as a roommate. When the original tenant left 5 years ago, I stayed on. At no point was I added to the tenancy agreement with the landlord. What rights do I have?
yeah, I think that goes back to something I mentioned earlier on about if it looks like a duck, walks like a duck, it talks like it's probably a duck. And so underneath the Residential Tenancy Act, it does contemplate situations where you might not have a written tenancy agreement, but the law actually says that even if you don't have a tenancy agreement in writing, the standard agreements of a tenancy agreement are provided for by the Act, and the regulations do provide those standard terms. And so you might find yourself in a situation contextually where even if you haven't signed an agreement, that depending on the length of the tenancy or the length of the occupation of that unit, depending on the, if it's your primary residence, depending on whether you have exclusive use of that premises, right? You might actually have acquiesced a situation where a tenancy is actually imposed in that circumstance. So, if you moved into that rental unit 10 years ago when your roommate left, and if your landlord did nothing about it, they may have actually implicitly walked themselves into a tenancy with the remaining individual based on the conduct between the parties. So again, very context driven to determine whether or not a tenancy exists. And even if it's not in writing, the tenancy agreement, the act does impose certain standard terms as between the two parties.
Interesting. So going back to our original question about tenant protections, that person who may be found to be in a tenancy agreement, if that is found, then they are then protected under the act.
Yeah,
Is that
definitely.
how?
They've received those protections with respect to reasonable notice against eviction, with respect to rent increases, et cetera. They'd have those protections. And in fact, last year I was involved in an interesting situation that was kind of similar, but in that situation, the individual, I guess, rented a room in a hotel for over a year. And so in that case, it was determined that because of these factors, length of the accommodation, exclusivity of possession, whether or not it was a primary residence, there was actually determined to be a tenancy in that situation, even though when they initiated, it was basically I'm renting a room for a really long time in a hotel situation.
Interesting. Thank you so much. Um, this next question is for you, Lisa. I'm a roommate not on the tenancy agreement with the landlord. I would like my cousin to stay with me for a month. Can the named tenant stop me from doing that?
Yeah. So, say if you are an occupant under the lease, so you're not a tenant, you don't have the legal rights that a tenant does with respect to the landlord, you still have to be cautious, you guys, about what you do in that rental property to make sure that it abides by the terms of the tenancy agreement. So, again, just remember that we have to check to see, do I need my landlord's permission to introduce somebody to the rental property? And in this case, if my cousin's going to be staying with me for a month, I want to make sure that my lease doesn't dictate that somebody staying with me, for example, longer than 14 days doesn't become an unintended occupant of the space and doesn't inadvertently breach the terms of the tenancy agreement. Although, as an occupant, I'm not responsible directly to my landlord for complying with the lease, it could get an end to the tenancy. So my tenant, my roommate who's identified as a tenant on the lease could be on the receiving end of an eviction notice because of something I did as an occupant. So you want to be very, very cautious before you introduce a new person to the property. And then apart from confirming with the tenant that this is actually okay under the lease agreement, what does my roommate agreement say? So hopefully you've got a documented contract with the tenant about what my rights and obligations are to them and what their rights and obligations are to me. And do I have the right to introduce somebody? So one of the things when you guys go check out the Tenants Resource and Advisory Center's template after today, you'll see that one of the things, terms that they recommend including in a template is how can I introduce guests or another roommate to the property? And so you'll want to make sure that whatever you do is in line with the agreement you've reached with your co-tenant as well. So can the co-tenant stop you? Maybe, depending on what the roommate agreement says. Can the landlord stop you? Probably. If it's a term of the lease, they can actually stop you indirectly through issuing an eviction notice to your roommate who's identified as a tenant under the lease.
Excellent. Thank you. And Lisa, we will provide links to the resources that you are referring to, along with the recording of today's webinar for anyone who's interested in looking at that more closely. And Neil, this next question is for you. I'm a roommate not on the tenancy agreement. The named tenant wants me to leave so that her boyfriend can move in. Can she do that?
Yeah, again, I think it comes down to the fact that you got to look back to that roommate agreement to determine what the rights and obligations are, if there are notice provisions, what those notice provisions entail, and how do they apply to the situation. By and large, and even if there isn't a formal agreement in place, if we look at some of the cases from the Civil Resolution Tribunal, they do say that even if there's not an agreement between the parties in the situation, the law does imply certain provisions like reasonable notice. And so that is likely, if you don't have a written agreement, you perhaps just look to reasonable notice for their eviction, and proceed on that basis. Arguably, nobody wants to be in a conflictual situation, so finding reasonable terms to facilitate that move out might be the best situation in the circumstances. But effectively, what does the agreement say? If there's no agreement, what does reasonable notice look like in the situation?
Excellent. Thank you, Anil. On a similar vein of what roommates can and cannot do, I'm a roommate not on the tenancy agreement. I moved in a year ago, and now my roommate wants to double my rent. Can they do that?
Well, perhaps first I can distinguish what the the Residential Tenancy Act provides. And if you're a named tenant on a residential in a normal tenancy, the Act says that for a landlord, they can only increase rent once every 12 months from the date of the last rent increase, and they have to provide about 3 months notice to do that. So that's the normal scenario, and that rent increase is generally capped at a certain amount, and that, for this year, I think it's 3.5%. In the situation where, you're a roommate and not on the lease, again, you got to refer back to that tenancy agreement. What does it say? Do you even have an agreement? And functionally, if you don't have an agreement, I think the sky's the limit for the named tenant, that they may potentially be able to raise the rent, double it or triple it, whatever they say fit. That said, again, if you have a tenancy agreement, that's perhaps your first place that you're going to look. Before entering the tenancy, or when it commenced or when you inquired, do you have any text messages? Do you have any emails that kind of explore or talk to these types of these topics? You're probably going to refer back to those and attempt to reasonably rely on such conversations as informing what you anticipated when you moved in.
Excellent. Thank you so much. So if we go back to Sheldon, we're hoping that within that phone book of clauses, we've got something in there
Pretty sure you did.
about
Pretty
the
sure.
rent increases. Lisa, this next question is for you, and this is a question that came up a lot when I was reviewing questions that had come in through the different channels. Some version of this. I took on a roommate to help with rent. I'm the only one on the tenancy agreement with the landlord. My roommate stopped paying the rent but won't leave. Can I evict them? And how much notice do I need to give?
Yeah, great question. And so this can happen, everybody. And so it's a lot more challenging when you're the only named tenant on a lease with your landlord. So the buck stops with you for all intents and purposes. So you are responsible for ensuring that all of the rent gets paid to your landlord, regardless of whether or not your roommate pays you their proportionate share, as you guys have made arrangements for. So it could get you into trouble. So you might be on the receiving end of a 10-day notice if you're not able to make rental payments in full and on time to your landlord. So that's a risk to your roommate as well in not paying the rent. So they might just get evicted by virtue of what the landlord does in terms of taking enforcement action against the named tenant. Can the tenant evict their roommate? Well, it's going to be a long process, everybody. So unfortunately, the residential tenancy branch does not govern disputes between roommates. So tenant versus tenant fights will not find an audience at the residential tenancy branch. The Civil Resolution Tribunal only deals with money fights, you guys, predominantly with respect to roommate disagreements. And so where we're left is having to go to Supreme Court, frankly, to remove somebody from a lease who we have a roommate agreement with. And that is a long and drawn out process. Usually what ends up happening in these types of scenarios is that the landlord, having not received all of the rent, will actually jump in and end the tenancy as a result of not getting the rental payment. In terms of how much notice you have to give to a roommate who's not living up to their end of the bargain, again, we're going to look to your roommate agreement. So what is reasonable notice in the circumstance? And what I would argue, frankly, in those scenarios is if I am bound by the Residential Tenancy Act with my landlord and my tenancy agreement there, my reasonable notice will probably be the same as what the landlord gives me. So 5 days to pay up or move out. So I would probably make an argument that that's reasonable in the circumstance. But as Anil said too, it will all depend on the circumstances. And so really, really strong implications, you guys, for anybody who stops paying their proportionate share. Even if their roommate can't evict them or cannot evict them very quickly, the landlord can if the named tenant can't make up the difference.
Thank you, Lisa. And I love how your answer has really highlighted how the law as it applies to the roommate situation is tricky, right? That eviction point that a roommate evicting a roommate doesn't have an audience, as you put it, at the residential tenancy branch or at the CRT, the Civil Resolution Tribunal, and so makes it harder to make that happen. So thank you for that. The next question is also for you, Lisa. So this is kind of a variation almost on that previous question. My roommate disappeared a couple of months ago, leaving behind a bunch of stuff and no money for rent. I'm the only one on the tenancy agreement with the landlord. Can I change the locks? And what do I do with all of their stuff?
Yeah, goodness. Okay, so this can happen. So your roommate might skip town and leave you holding all of the responsibility to your landlord in terms of paying the rent and leave some personal belongings behind. So in terms of changing the locks, you guys, you don't have the right to change your locks without your landlord's permission. So if you're the named tenant under the lease, then it's very, very clear under the Residential Tenancy Act that you cannot unilaterally change access to the rental property. You have to let your landlord know, and you have to get their permission before you do that. And in this situation, my hunch is that the landlord would be in agreement with changing the locks because you'll want to make sure that your housing security is protected there. With respect to the belongings that are left behind, I'm going to give you, unfortunately, a typical lawyer answer, and it will depend. So when the person left, did they indicate that they don't want any of these belongings, or the property that they left behind, is it of any value? Is it perishable items? Is it hazardous to keep in the property? The law doesn't have an independent obligation on you to store your roommate's stuff. Now, when it comes to a landlord, landlords actually have obligations with respect to abandoned personal property, and the law has actually changed with respect to what those obligations look like. But before you start tossing out your roommate's stuff or selling it off to pay the rent, be very careful to look at your roommate agreement. What does it say about our personal belongings? That's usually something I like to see in a roommate agreement. So when somebody vacates, they have to remove all their personal belongings and have them initial a clause that anything left behind is forfeit. So they don't claim any interest or entitlement to that. Another sort of word of warning, we don't want to assume that the belongings that they left behind are their belongings. They might actually belong to somebody else. They might have been using them, but they could have been leasing, for example, the equipment that they were using, media equipment or what have you. So you want to make sure before you bin anything that there's no potential claim for this stuff.
Excellent. Thank you. Um, this next question is for you, Anil. Again, a real life scenario that was written in. My roommate flushed a bunch of things down the toilet and damaged the pipes. I'm the only one on the tenancy agreement. Am I responsible to the landlord for damage? If so, can I recoup my money from my roommate?
Gosh, when I first read the question, I just wondered, well, what do they flush down that toilet? But I'll stop thinking about that one. But going back to the question, generally, the law, requires that the named tenant be responsible for the damages, because when you look at the tenancy agreement between the landlord and the tenant, there's probably going to be a provision that says in the law, actually kind of speaks to this, that they're going to be responsible for any damages caused either deliberately or as a result of neglect by the tenant or their guests, occupants, what have you. So in this situation, unfortunately, that named tenant is likely going to be responsible to the landlord for the damage. That said, what does that tenant then do with respect to recouping any of the funds that they've expended to address the damage? Again, going back to the roommate agreement, are the provisions that speak to damage, and how does that kind of unfold in responsibilities and repayment, et cetera. If there isn't an agreement formally per se, well then there is an opportunity, and this is obviously if you want to go down that road, is you could commence a claim in a place like the Civil Resolution Tribunal that has a monetary limit of claims for 5,000 and under, and you could attempt to pursue a claim there to seek reimbursement. Generally speaking, your claim would be based in negligence, which means you'd have to prove a couple of things. For example, the duty of care, a standard of care, a breach of that standard of care, and the damages that resulted. So there's a bit of a test to meet in that situation. So that's probably how you try to recoup your monies expended. That said, as the named tenant, a good offense is sometimes your best defense. In that situation, you might want to look and ensure that you have something like renter's insurance that, depending on the nature of those damaged pipes, and that can be pretty expensive depending on the circumstances, you might want renter insurance, or, encouraged to have it to help offset any expenses that might result from such an act.
Excellent. Thank you so much, Neil. A couple more questions for you, and then we're going to turn to the live questions, or sorry, the questions coming in from our guests today. Um, my roommate keeps paying rent late. I want to talk to her about paying on time, but I don't want things to get awkward. What tips do you have?
Yeah, the first two things I would say is A, don't let it drag out. If you allow this conduct to continue, there's a serious concern about, whether you've acquiesced or you're permitting this conduct to occur, which then would potentially impact your legal rights. Number two, do you have an agreement with your roommate? Does it specify the terms of what their obligations are? Because that'll help inform your next steps. But in terms of raising the issue with your roommate, I think a couple things to look to is number one, what is your relationship like with your roommate? Is this person or was this person your best friend? Or are they a work colleague? So you want to consider what your relationship is, what it means to you, because that's going to inform how you approach, I think, the subject of their conduct. Number two, they may not even know it's a problem. So don't assume that they know it's a problem, that they're purposely not paying you rent on time. So being very clear about, don't make that assumption. Three, and sometimes difficult conversations are difficult to have. So think about how you want to raise the issue with them. Be very clear, precise, and perhaps very neutral and objective about the relay of information. And so those are three tips that I would put out there in terms of how you communicate it. But again, number one, don't sit on it. And number two, look at your agreement if you have one.
Excellent. Thank you so much, Neil. And then one final question here. I tried to evict my roommate and they will not leave. I need to escalate things. Where can I take my dispute? And we have RTB, so the Residential Tenancy Branch, the CRT, the Civil Resolution Tribunal, and the HRT, the Human Rights Tribunal.
Yeah, so I think Lisa spoke to it earlier. And so the RTB is not going to entertain disputes between roommates. So that venue is kind of out the way. With respect to the Human Rights Tribunal, that's a venue that addresses violations of the Human Rights Code. And so in most circumstances, I'm pretty sure that in the circumstances, you're not going to bring a claim there for an eviction. And with respect to the CRT, the Civil Resolution Tribunal, I actually went through their dispute explorer, and it says at the outset for roommate disputes that the CRT does not have jurisdiction or an ability to order an eviction. So the CRT is also out. So what does that mean? You probably have to go to the Supreme Court of BC to file a petition proceeding, and that's a proceeding by paper, by affidavit, to seek an eviction of your roommate. And as Lisa knows as well as I do, that going to the Supreme Court can be a very costly venture, can be a very lengthy venture, and justice takes time, so it's not going to be an easy one. So realistically, in such a situation, I would go back to what's the root cause of the eviction. For example, is it because your roommate isn't paying rent, etc.? Are they disputing that there's a reasonable notice provision in the arrangement between the two parties? Because that is where the CRT can be useful, and the CRT can award damages for things like failure to pay rent between roommates. They have case law that talks about the imposition of a reasonable notice period provision in informal situations. So you might want to get direction from the CRT in terms of what your roommate agreement kind of looks like if there isn't a formal one. So they have capacity to do those types of things. And that might be your best mechanism to at least arm yourself with something tangible in a way that's not as expensive, not as lengthy as a Supreme Court claim.
Excellent. Thank you, Neil. And Neil, as you were talking, I was having a quick look at the questions that have come in, and one of them is quite relevant to the question you just answered.
Mm-hmm.
In the event that a roommate is being asked to leave and refuses to do so, guidance on both People's Law School and track websites say you need to go to court, as the RTB dispute resolution process does not apply. What would you be asking for in this scenario? Can you request an eviction notice from the CRT or small claims?
So I don't think small claims has the capacity to address this type of issue. The CRT, I think what you'd be asking them, you wouldn't be asking for an eviction order. You'd be asking for, respect. If, for example, if they're not paying rent, you'd want the damages. If you're looking for, if you're looking for an order or decision that refers to an implied reasonable notice provision within the arrangement between the two parties, that's what I would be looking for. Functionally, when it says court, they're talking about Supreme Court of British Columbia, which is a petition proceeding, which is where they would grant the eviction if there's enough evidence for them to do so.
Excellent. Thank you. Here's another question, and Lisa and Neil, I'm not sure which of you would like to answer it, but I'll put the question out there, maybe both of you. If a landlord shares the kitchen with their tenant, would that be considered a roommate situation? In that case, what protections would they have if the Residential Tenancy Act does not apply?
So I can hop in. So Section 4 of the Residential Tenancy Act outlines the different types of living accommodations that don't fall under the RTA. And so when an owner of the property shares kitchen and bathroom facilities with a co-occupant, then the RTA doesn't apply. It doesn't mean that they're not a landlord. It doesn't mean that they might have, for example, a license to occupy arrangement with people who are renting rooms from them. But typically speaking, the RTA doesn't apply when you have those shared facilities. And I'd want to take a double check of the act just to see if it has to be kitchen and bathroom or kitchen or bathroom. Is it or?
Or,
Yeah,
yeah.
or so yeah, so the RTA is not going to help you guys. So you would be looking at what is the basis of the contract? Are they just roommates? Or is this a license to occupy, or is this something different? So we would probably pop the hood and see what the relationship is like a little bit more.
Excellent. Um, Here's another question, and I think we've addressed any. I'll read the question and then invite your thoughts. If a roommate who you have a tenancy agreement with for a room and who holds the tenancy agreement for the whole unit evicts you based on having a family member move in, are your rights similar as they would be with the residential tenancy branch? How do they differ? Does a few weeks, months, and then I think what they're asking about is notice constitute having a family member move in? Not, or sorry, not notice. Does a few weeks, months constitute having a family member move in, not their primary residence? So maybe that's getting to that occupancy question.
I can maybe jump in a little bit. So I think where this is speaking to is so under the Residential Tenancy Act, if a landlord wants to move into the property or move a close family member as defined under the legislation, which is going to be their spouse, their parents or kids, or their spouse's parents or kids, then there are notice requirements that the landlord has to issue to their tenant. And they've actually recently changed it to 3 months notice, guys. So it was reduced just last week from 4 months to 3 months notice. But with respect to a roommate who is not an identified tenant under the lease, who is just renting a room from the tenant of the property, the law doesn't impose those types of requirements. So whether or not somebody reviewing the situation might consider reasonable notice would be what the law requires landlords to give in the circumstance. It really is up for grabs. I'm not aware of any cases decided by the Supreme Court of that particular scenario. But I would check the roommate agreement with respect to reasonable notice as well. So it might just be that your tenant roommate might be able to ask you to leave for any reason, not just that they're moving a family member in. And that could be on 1 month's notice or 2 weeks notice or 2 months notice. So the law around what landlords can do for their tenants when they're moving in a close family member doesn't strictly apply to that relationship.
Excellent. Thank you, Lisa. Here's another question. Sorry if I missed this, but if the landlord evicts a tenant, then the occupant also gets evicted automatically.
Yep. Both
That's a
Emil
simple
and I
one.
are nodded. Yeah.
Yeah.
You're all in it together. You're just not necessarily on the lease, but when somebody issues an eviction notice, they require the property be fully vacated. And that means everybody living in the property has to go.
Excellent. Here's a question. Can roommates create a contingency fund that they both contribute to in case one of them leaves on short notice?
I guess, theoretically they could if they wanted to enter into that type of arrangement, if their agreement provides for, parameters around what that looks like and et cetera. I guess it's possible.
I'm sure Sheldon had one.
In the phone book, exactly. Here's a question that follows up on the question about strata units. If a strata unit owner fails to reveal to the tenant that there are strata rules, so this Form K, is the tenant still bound by strata rules, or can the tenant use that failure to argue short notice to vacate due to unacceptable strata rule that had not been revealed?
So the Strata Property Act does allow a tenant to end their tenancy early in the event that they are not provided with, I think it's the Form K. I'd have to double check under the Strata Property Act. So there are certain grounds in which a tenant can end their fixed term tenancy, which ordinarily they would be stuck with, if they were not brought to the bylaws before the commencement of the tenancy, before they moved in. And this usually arises when the tenant, for example, introduces a pet to the tenancy agreement silent on pets, but the strata has a no pets bylaw. And so they're potentially on the hook for getting fines or what have you. So I'd have to double check into the act, but there are some circumstances in which the law allows a tenant to end their tenancy early.
Yeah, so I just done that quickly right here. So it says here, section 146.3 for those who are inquiring. It says if the landlord fails to comply with, with the Form K provisions, the tenant is still bound by the bylaws and rules, but may within 90 days of learning the landlord's failure to comply, end the tenancy without penalty by giving notice to the landlord.
Excellent. Thank you. Um, Thinking on the fly. Um, we have another question here. If my lease says there can't be anyone new living in the unit, does that count a new baby?
I would say probably not. And this is where, reference to the Human Rights Code also comes into play, right? And so, there a protected characteristic is family status. And so having a child is considered as part of one's family status. And so likely, while you could try to argue it, I would really hesitate and encourage against it. There are situations where, having a growing family could give rise to some type of grounds for an issue, but the evidentiary record to show why having this increased minor body negatively impacts the tenancy to the point where an eviction might be warranted is a pretty high standard. Keeping in mind that under the Human Rights Code, Section 4 specifically says that if there's a conflict between the Human Rights Code and any other law or legislation, the Human Rights Code prevails over all other laws, right? So, even if there's a small little child coming into this world and it impacts it as an additional occupant, I would be somewhat hesitant. And obviously, context is the driving force amongst everything we do here. But I'd be very hesitant to want to, jump on that one and try to do something adverse to the tenancy.
Excellent. Thank you, Anil. Here's another question. Um, does protected categories discrimination under the BC human rights apply to screening for rooms available for rent? Can a person renting a room in their home with shared kitchen or bath discriminate for protected categories?
Well, the Human Rights Code applies to people, and so you can't discriminate against somebody in terms of providing housing that's otherwise available to rent on the basis of a personal characteristic. There might be a bona fide, reasonable justification or a defense for not introducing certain people to the property. So, for example, if you I'm just trying to think out loud here, but if you are a young woman and you would prefer to have a female roommate, then potentially there might be a viable defense for you being able to restrict the category of person that might be a roommate with you. But the Human Rights Code does apply to activities with respect to housing and offering spaces available for rent. So I'm going to give you the typical lawyer response where it depends. We would want to know more. Why are you limiting the space and to what degree? But we always have to be mindful of not denying someone the right to live somewhere on the basis of who they are.
Excellent. Thank you so much. One last question before we're going to wrap up. And I wanted to say a big thank you to everybody who is submitting questions today. These are really great questions. And Lisa and Neil, you're doing such an amazing job of answering these questions on the fly. So thank you. This question is, can the landlord sign a separate rental agreement with each of the roommates? What are the pros and cons for the roommate and for the landlord?
So in this situation, I'm going just to assume it's, say, for example, a big house, you've got a bunch of bedrooms, a communal kitchen, bathrooms, and the landlord doesn't reside in that home with the roommates. I've seen landlords do that, and technically, this is a situation where a landlord will have separate agreements between these individuals. The pros and cons. I guess it really comes down to what is the objective of the landlord. You know, vis-a-vis the roommates. The one I'll bring that comes to mind is the right to quiet enjoyment. Now, normally, if you are both individuals, co-tenants signed on to a tenancy agreement with the landlord, there's no real argument for right to quiet enjoyment. Conversely, in a situation where you in communal living in a multi-residential building, for example, you have to be mindful of your neighbors, and your neighbors have a right to quiet enjoyment. So in a situation where a landlord has entered into these separate arrangements with individuals that reside in that in that situation, if one tenant bothers the other and ruins their quiet enjoyment, the landlord would likely have an obligation to step in there and to address that issue. That's one big issue that I would see in that type of arrangement.
That wraps up our webinar for today. Thank you again to Anil and Lisa for your incredible answers to all of today's questions. A big thank you to all of our guests who joined us here today for today's webinar. Thank you for your questions. Thank you for your participation. It really is wonderful to be able to host these webinars for you. Lisa, I'm going to start with you. Thank you again. Webinar number 6. Well done. Such a pleasure to have you here. Anything that you'd like to share with our guests before we wrap up today?
Sure. I think I was really compelled by that question about human rights and how we could pick and choose who we live with and being mindful of everyone's personal characteristics. What I would say, just as a lingering thought, is that Anil and I have chatted about a lot of different laws today, the Human Rights Code, the Residential Tenancy Act, and these laws can be complicated, and it's important to get legal advice if we have a question relating to our particular situation. And so just during the break, I was looking at the Human Rights Code as well, and there are exceptions with respect to certain styles of living accommodations and rentals. So really, really important that we dial in beyond today's discussion as well. So great questions. And it makes sense because we were dealing with housing, which is so personal to our identity and who we are. So amazing questions.
Brilliant. Thank you so much, Lisa. Again, appreciate you joining us and rejoining us, and we'll hope to see you again at future webinars. Thank you. Anil, again, likewise, so grateful to have you here today to share your insights and knowledge with our guests. Would love to hear if there's anything that you would like to share before we wrap up today. And again, congratulations, 3, 3 webinars. Thank you. Thank you.
Thank you. No, again, yeah, everyone, great questions. I think if I take away from one thing from today's, presentation is, having a document, using Sheldon as your inspiration, putting it on paper, is probably the best thing you can do for yourselves. And I know when it comes to sharing rooms or talking to people that you know, friends, it sometimes can be a difficult thing, but this is how you maintain friendships, you maintain work relationships, etc., by keeping it very clear and easy and on paper, because paper never lies.
Amazing. Thank you so much, Anil. Again, appreciate you coming and sharing all of your knowledge with us, information. It's fantastic. And yes, let's make those agreements while everybody's at the front end as opposed to waiting for things to go sideways. Thanks, everybody. Thanks, everyone. Have a wonderful rest of your day.